Good afternoon. Our sign language interpreter is Meresha Owiti and I am Akisa Wandera. 7 officials of the Doctors Union KMPDU have started the 1-month jail term handed down to them for contempt of court. Judge Helen Wasilo lifted suspension on her 1-month sentence after the officials failed to comply with her conditions. The judge had asked the top officials of the Kenya medical practitioners, pharmacists and dentists unions to call off the strike and engage the government in talks. The court-mediated talks appeared to have hit a dead end, with Kotu boss Francis Atwoli admitting that he had failed to clinch a deal. Let's now cross over to our city centre studios where we will be speaking to our reporter Rita Tinina. But before we speak to her, let's take a look at what happened in court in the morning.
Being considered or where an appeal is not allowed. In the case of the applicant's hearing, however, this court has already been notified that they have filed an appeal at the Court of Appeal, and at the same time they have filed for review, which in my view is tantamount to forum shopping. This was the holding in the Court of Appeal case of William Karani and 47 others Supra, where the court found that once an appeal has been taken, the review cannot proceed, and the issue ought to be remedied by the review must be merged in the appeal. On the second issue, the court has already determined that it has inherent powers to review its own judgment and orders as provided for under the LRC Act 2016 and even the Civil Procedure Act. This inherent power of review was tested and applied in the case of High Court Civil Case number 45 of 2008 Machakos, where the Honorable Justice Atari Waweru considered an application for review in a contempt matter and dismissed it, as there were no valid reason to warrant the review. This same power of review is not ousted by the new Contempt of Court Act 2016. However, the Contempt of Court Act, having come in force on 13th of January 2017, will not apply in this case, as the contemnors were sentenced by this court on 12th of January 2017, and the new act cannot act retrospectively. Under Section 9(2) of Cap 2, Interpretation and General Statutes Act, if it is enacted in the Act or in any other written law that the Act or any provision of thereof shall come or be deemed to have come into operation on some other day, the Act, or as the case may be, that provision shall come and be deemed to have come into operation accordingly. In this case, therefore, the Contempt of Act 2016, it came in force as stated therein on 13th of January 2017, and so cannot apply retrospectively. This also answers my issue number 3 above. Given that I've answered issue number 1 above in the negative, it will be superfluous to go and answer issue number 4 above. Nonetheless, I will answer the question by stating that considering the parameter to be applied in declining whether to allow a review or not, the applicants must demonstrate to court that there is discovery of new and important matter which was not in their knowledge before, or that there is an error apparent on the face of the record, or that the ruling requires some clarification or interpretation for sufficient cause. The applicants have demonstrated to court they have not demonstrated to court any new and compelling issue or pointed out any mistake or error apparent on the record, nor any sufficient cause that will warrant review of these court orders. Indeed, they have submitted that they are engaging in negotiations ordered by court on 1st December 2016, but they have not explained why they chose to obey part of the order and fail as officials of Kenya Medical Practitioner and Dentist Union to call off the strike as ordered by the same court. Indeed, they have also found their inability to call off the strike, which they themselves called on,